Hello and welcome back to the Ray Law International channel. As you know, the many parts of our U.S. immigration system is in shambles, and on top of that, COVID variants that are taking hold of many countries has resulted in the White House proclamations making immigration even more challenging. Because our immigration system is unorganized, inefficient, and constantly changing, you know there are going to be problems. So, in today's video, we're going to take a look at some of your questions and see how we might navigate the current complex immigration system. Let's get started. First, it is very important that you study the correct civics test materials. The USCIS has recently issued a 2020 civics test. Even so, beginning on April 2019-21, the USCIS will only offer the 2008 civics test at the initial appointment, regardless of your filing date. So, if this is your initial interview, you need to make sure you carefully, thoroughly, and repeatedly review and study the 2008 civics test questions and answers. You will need to study 100 questions about American government and history, in which you must answer correctly 6 of 10 questions to pass the civics test. All questions on the test are asked orally by the USCIS officer. The USCIS gives applicants 2 opportunities to pass the naturalization test. So if you do not pass the first time, you will be retested between 60 to 90 days from the date of your interview. But you do not want to risk failing the test at your second interview, so make sure you study, and study some more. You have a few options. However, it is important to note that it is best to consult with an attorney on the best course of action. This is because the recommended course of action will highly depend on the reason for the denial of your green card. For example, if the USCIS ignored facts of law that would have lent itself to the approval, the best course of action may be to file a motion to reopen or a motion to reconsider. But if you missed a clear deadline, such as a request for evidence deadline, without any valid reason for doing so, then the best course of action may be to reapply. In doing so, you will not waste your time and money. The major downside of having to reapply is that you cannot just reapply for your green card. You must go through the whole process all over again. This means having to apply for the U visa, getting it approved, waiting for 3 years, then applying for your green card again. Either option requires a huge investment in time and money, so it is crucial that you speak with a knowledgeable and experienced attorney to determine what is right for you. First, you must always disclose information that is being requested by the USCIS. The USCIS imposes steep penalties for fraud and misrepresentation. Such penalties can include deportation and bar you from entering the United States. The fact that your criminal record is expunged does not necessarily mean that it is wiped clean forever. For example, in the United States, law enforcement and courts can continue to view expunged criminal records. Now, the USCIS has full access to a person's criminal record. This includes citations, arrests, charges, convictions, and yes, even expunged crimes. So, if you have any sort of criminal history, you should expect that the USCIS will be able to easily access such information. And if you do not disclose this information, your future in the US may be jeopardized. Due to the skyrocketing number of COVID-19 cases in India, at the time of this video, President Biden issued a proclamation suspending entry of non-immigrant and non-U.S. citizens who are physically present in India for a 14-day period preceding their entry into the United States. A person on H-1B status is considered a non-immigrant. But if you are a non-immigrant, you may not necessarily be affected by the proclamation. This is because there are exemptions. For example, if you are the spouse or parent of a U.S. citizen or legal permanent resident, then the proclamation does not apply to you. If you do not meet any of the U.S. exemptions, then the next option is to apply for the national interest exception. As an H-1B holder, you may qualify for the national interest exception if you can prove that you provide significant support for critical infrastructure sectors. It is then the sole discretion of the U.S. Embassy or consulate to determine whether they believe you satisfy this exception. The other option, of course, is to not travel to India unless you absolutely must. COVID-19, especially in high-risk countries, has made traveling very unpredictable. Depending on your country, B2 visa stamps are usually issued for a term of 10 years. During that 10-year period, each visit may only last up to 6 months. In other words, even though the H-2B visa stamp is issued for 10 years, CBP will only grant B2 status for up to 6 months at a time. As of late, the USCIS has been slower than ever in processing B2 extensions. The processing times for these cases ranges between 7.5 to 10 months. You can see the processing time is longer than the 6 months approval period. So when you apply for the B2 extension and your extension application is still pending, you do not need to leave the US during the pendency of your application. But you do need to be mindful of filing renewals every 6 months so you can show that you have maintained your status. Now, more than ever, it is important that you have an immigration attorney involved in your immigration case. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Stay updated on immigration matters by subscribing to our channel and sharing these videos with your friends. Stay informed, stay educated, and until next time, stay on the right immigration path.